Hey everyone, and welcome to the day 87. We are at day 87 of the Young Thug YSL RICO. And for those who want to join us, we appreciate it. But we've been with this case from day one, so we really know what's going on in the case. If you want to catch up with the case, you can also go on my channel and start from there. Okay, from day one. Now we got a witness to come in, and they have a problem trying to get a couple witnesses to come in that has been subpoenaed to come to court, and they trying to not show up. And you know, if you don't show up and you're supposed to, you can get locked up. But so right now we're gonna tune into the state. They are talking to the judge here about their witnesses. Okay. And hey, only focus on the case. Don't judge me and my commentary. Tell me what you think about what's going on in the case and what can they do, what they doing. You know, anything you want to talk about in the chat, okay? In the comment section. Love y'all.
We had that conversation with him as well, that he could be held in contempt if he does not testify, Your Honor. And so the state would ask that the order that the court has signed be honored, and that Mr. Copeland be compelled to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
That's not good.
Yes, you can, Mr. Miller. So, Mr. Melly, here's the thing. Your client can certainly advance his Fifth Amendment privilege and self-incrimination. I have signed the order under 24-5-507. So I guess have you explained to your client the potential second and third order effects that could occur depending upon his decision?
I have, Judge.
Okay. I guess the only thing to do at this point in time is to bring him in and determine whether or not he would like to make sure he understands.
I understand
Where he is under 24-5-507.
He is present in the courtroom, Judge.
Okay.
What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Yes.
Okay. Come on up, Mr. Copeland.
Mr. Copeland, come on up and have a seat here, sir. No, he doesn't need to be sworn in yet.
Mr. Copeland got on his little tight pants, really about it.
All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
All right. Has the state provided you a letter of immunity or a copy of the order that I have signed directing that they give you use immunity?
Yes.
Do you have a copy of it?
Yes.
All right. Can we see that, please? Can I need 2 copies of it. Actually, 3. Not yet, sir.
Y'all calm down. Let the judge do one step at a time. Y'all doing too much.
But it is going to be part of the record, but still, I haven't filed it yet under Odyssey. I don't think it's made the Odyssey system quite yet, so anyways. Huh? But I signed the order this morning, though. Okay, all right. Which copy's been given to Mr. Copeland? The order pursuant? All right. All right. Do we have extra copies of that? All right, Mr. Copeland, I'm going to mark this as the next court's exhibit in order, okay? Mr. Copeland, can you take a look at that order for me, please, sir? All right, let's just go through it right quick, okay? I just want to make sure that you understand where you are, and you have your attorney here, and if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right. I'm not trying to trick you. I'm not trying to do anything other than explain this to you, all right?
Okay.
Okay, all right. Mr. Copeland, this order reads basically, the state of Georgia has moved the court pursuant to this particular statute, which is 24-5-507, to compel your testimony, and our district attorney, Ms. Willis, having determined that your testimony is necessary to the public interest. And that is, and if you take a look at the footnote, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So
He ain't gonna
and it's in the
cooperate.
public interest. So you've been subpoenaed in this case to appear before and give testimony in this particular matter, and state has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. So that's how we
roll.
as a due process gets you to come to court. I mean, you were noticed as a witness, they've identified you as a witness, they determined that your testimony is needed. Because of the fact that you have some concerns about what your testimony may indicate, or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they wanted in this case, for you to testify. So your attorneys told me you're going to invoke your Fifth Amendment privilege. Done, said. However, the immunity's been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
You need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the field.
Okay, you've taken the Fifth, but you've got immunity, but you still want to, are you going to testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's giving you immunity, so that overrides that Fifth Amendment privilege.
He don't want to talk. Y'all making him
But the
talk.
state don't know what they're talking about. So if they ask me a question, they implicate me, then
Okay, they can't prosecute you on that. They can't. The order
Them boys know how y'all are judged.
from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but Mr. Melnick is a very seasoned criminal defense attorney.
Y'all heard what he said. Then the state don't know what they talking about.
Very, very good advice, but the state can't use that testimony. They can't kind of say, have it both ways. Like, you testify and then use that against you to indict you and prosecute you. Then we wouldn't have any faith that we need to have people
Testify, baby.
give testimony. So that's why they can't do that. They kind of can't go back on what they're going to tell you, So I signed the order. Now, they've asked for immunity. I've signed the order. So basically, whatever you have
Tell
to
him you don't care. No.
say no more.
Do you wish to testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I can tell him whatever I got to tell him.
That's
So
fine.
I testify.
You will testify.
Yeah.
All right, sir. Okay, what we're gonna do in just a second is, I'm gonna go ahead and I'm gonna call for our jurors. We'll formally administer the oath to you, and then the state will ask you some questions, okay? And then you'll be cross-examined at some point in time by potentially some...
My attorney, because I think I just said the wrong thing.
Sure. I'll tell you what, why don't you step outside and talk to Mr. Melnick.
Y'all making that boy mad. Y'all ain't gonna get state. Y'all ain't gonna win with him. Ooh, he mad at y'all. I mean, he is upset. All right, state. Y'all ain't gonna hang on that. He ain't gonna do right. Hush, Camper. That boy ain't gonna. That witness right there, it's not gonna do right for y'all. Camper. Look at this dog right here, y'all. Ooh, Camper. Jesus. I mean, that witness right there. Oh, wait, honey. Let me skip this, y'all. I got to see this for today.
Come on up, Mr. Copeland. Hi, sir. What's your pleasure?
Say what?
I said, what's your pleasure, sir? Do you wish to give testimony? I know you don't want to give testimony in this case, but you've been given immunity in this particular circumstance, use immunity. So, are you going to testify?
Yeah.
Okay. All right. All right, sir. Then what we'll do at this point in time is we'll call for our jurors and we'll swear you in, and we'll go ahead and take your testimony. Okay.
All right.
All right.
These guys don't.
What is it, Mr. Steele?
So still need to sit down.
Does a witness need to be excused? Yeah, sir. Go ahead and stand outside, please. If you wouldn't mind, we'll call you in just a minute.
Come on, Mr. Steele.
Mr. Copeland has left us. Yes, sir. What's your pleasure?
Well, Your Honor, good morning to everyone. Your Honor, I would like the court to weigh in on this, please. I would like it now, that's why I raised it, but if you do it on a break, that's fine. I mean, whatever you want. But I'm citing for court two cases, if you don't mind. Franklin, which is Franklin, like Donald Franklin Samuel, versus State, it's 166 Georgia Appeal 375. Yes, of course. 166 Georgia Appeal 375. It's in Division 2, 1983.
What's up,
Also
Thugger?
Waldrip, which is Waldrip, versus Head, like Bubba Head, and that's 279 Georgia. 826, that's Division 2. It's Roman numeral 2A, capital A. 620 Southeast 2D2. Oh, that's wrong. 829 2005. And Your Honor, what I'd like you to do is the state has stated today, and Ms. Hilton told me this last evening, I don't remember the time, but maybe 6 o'clock, 7 o'clock, something like that. We had two telephone conversations. She said that she's met with Mr. Copeland and other members of the prosecution team. I asked for any notes that were entitled to exculpatory information under Brady. Ms. Hilton told me that there was one statement, and she emailed that to me, to everyone on the defense side. But, Your Honor, I don't have any of the other notes. Mr. Copeland met with law enforcement on the January 11th of 2015. So, God forbid, the killing of Mr. Thomas is at 7:22 approximately, January 10th, 2015. By the early morning hours, I'm going to tell you about 4 in the morning, Mr. Copeland is on video, audio recording with Detective Thorpe the next morning. So it's January 11th, 2015. And he made statements that he knows nothing about anything. Since then, he has made additional at least 5 recorded statements that I'm aware of, and he's made other statements that I have nothing on. Anything that, and he's been inconsistent. So anything that he told the state in this preparation would be inconsistent statements, which is impeachment evidence under Brady.
Come here, Captain.
And the state, I presume, will claim work product.
Sit
That's
down.
why Ms. Hilton didn't give us any of the notes. But work product of the state is not subject, is typically not subject to compelled discovery, except to the extent that such notes may be exculpatory and must be disclosed under Brady versus Maryland, which is 373 U.S. 83. That's under Franklin. And then Waldrop versus Head says that work product doctrine gives way to the accused constitutional right to exculpatory and impeaching evidence under Brady. So what I'm asking this honorable court to do is order the state to produce all notes. They have investigated. If they don't want to do that, I ask the court to get a copy of the notes in camera inspection, and then meet with us ex parte so we can tell the court what we believe would be inconsistent statements, which is impeachment. That's why I brought it up to the court.
Your Honor, as I discussed with Mr. Steele last night, I turned over the statement that I believe was Brady, which was what Mr. Copeland told me about an incident in which there was a theft. And I provided that information to defense counsel. Outside that, the state doesn't have any notes. And so there's nothing else to turn over except for what I did turn over. We do have one additional matter, Your Honor, which would be criminal convictions that I would like to address.
Okay, let's deal with the issue of the first issue of the notes, okay? Do you have any written notes from your interviews of Mr. Copeland? What Mr. Steele is basically saying is that Mr. Copeland's given a few, he said 5 statements, and that some of those may be inconsistent, which would fall under the category of Brady, or may fall in the category of Brady. So do you have any written notes that you or your team took that arguably would be work product, but that I would need to review to determine whether or not they are on Brady?
We do not have any written notes, Your Honor.
All right, Mr. Steele, then that satisfies that issue in terms of that. If I find out that there's any other additional notes, then I'll change the terms of my consideration on that issue.
Your Honor, and I'll get you the case in a moment, because I don't have it on my mind, unless someone else does, but oral statements must be reduced to writing or written.
Yeah. But I think they're saying to you that the only statement that they have that's Brady is the one statement they turned over already.
And Your Honor, furthermore, in addition to that, in our conversations with Mr. Copeland, he didn't give us any different information than what is contained in the 6 interviews that defense counsel has had since 2022. So there's, outside of this one sentence or this one piece of information which we gave, our conversations were not.
There's nothing. Are you telling me that there's nothing that that needs to be reduced to Brady?
Correct.
Produces Brady.
If there was, we would have reduced it and sent it.
All right. Okay. All right. Let's talk about prior convictions. Where's Mr. Melnick? you have him come back, please?
Miss Love, why you can't sit still? Something ain't right with it. You just like a child, won't be still. That lady right there act more like the lead prosecutor. Look at her, can't sit still. Just sit down.
All right, Mr. Melnick, I wanted you to be here for the this part of the conversation in regards to your client, because these are prior convictions, okay? All right.
Your Honor, Mr. Copeland has a total of 11 convictions, Your Honor, prior convictions. However, based on 24-6-609, we believe that only 4 of them will be able to be discussed during the pendency of this case. The state has not received, and if any defense counsel can correct me, any notice that they wanted to use any convictions greater than 10 years old. And so I wanted to put on the record the convictions that are greater than 10 years old. Again, I did not see any notice that any defense counsel intended to use these, so we can
Or the state's intended to use any.
or the state's intentions to use any of them, so that we could have argument on those. So the convictions that I believe should not come in are as follows: 09 SC 82479, which was a September 1st, 2009 conviction.
Four.
That one was for theft by taking.
Okay.
Answering auto and other charges.
That's why he didn't want to talk to y'all, because he already dealing with his other charges. I wouldn't want to come to court either.
So make sure that he didn't plead to. You know, in all candor, Your Honor, I believe he did plead to giving false info. So for the 09 case, he did plead to giving false information. So they would be able to use that for that limited portion of the fact that he did plead to giving false information.
Yes, that part would be.
That part would be. The next case we have, Your Honor, is 10 SC 87662. And he pled in 2010, but he ended up pleading to a misdemeanor. He pled to misdemeanor theft by receiving. The next is 10 SC 96.
10 SC 96.
938.
Okay.
And that plea was taken on March 7th, 2011.
So
And
why?
the charge was aggravated assault.
So now we trialing him.
Possession of a firearm during the commission of a felony.
Y'all making that boy look bad, like we.
By prior conviction. 609B. 609B. So, Your Honor, the statute says or release from confinement, whichever is the later date, is what I was referring.
Okay. All right. Can we summon our participants, please?
I skipped a little bit, y'all, because I don't need all that other stuff. Campus, say hello. Tell everybody hello. Tell everybody say hello, Minnie. We chilling, y'all. We done been out earlier, so I'm on rest right now. Okay, let me skip it. What is taking them so long? Here we go, y'all. Let's skip to some more, y'all. Sit down, Campbell. Sit down. Sit down.
Oh, waiting. Where's Mr. Melnick?
Lay down.
And Mr. Copeland? He's waiting. Okay. Okay.
Sit down. See, that's what I'm saying. That's why I said sit down. Cause
Left us. I'll see y'all back at one. All right. Can we summon our participants, please?
he didn't have to testify, y'all.
If we have any specific redactions after their redactions, we'll bring that to Your Honor's attention, if that's okay.
That's what you told me, so I certainly understand that.
Right. So what happened since that hearing or that discussion was the state did make some redactions, and I think that addressed possibly all of our issues, but at least some of them. But we just received this, so we'll report back to the court whenever Your Honor wants to
Okay,
hear
but
from us.
remember, our jury's been here since 8:30,
No, I understand that.
so I'd like to kind of go ahead and get started.
But if Your Honor wants to go through these one by one, we can. We just literally
Well, you
just
can do
got
that during lunch. That's fine.
Okay,
I mean,
okay.
But you know, this is I know that you all we should have been working on these prior to that. So, okay.
Yes, we just got this.
Okay, but you had the larger exhibit for the.
And we brought those to your attention last week.
Yeah, I remember.
Okay.
I remember. Okay. All right. All right, Deputy Ham, summon our jurors, please.
Hey, Thug. Hey, Miss Steel. Still got his whole class in the courtroom.
Oh, waiting. Where's Mr. Melnick? And Mr. Copeland? He's waiting. Okay. All right.
I think they dragging this RICO. He on his cell phone. Strike that.
Can we call him, please? Or tell him that we are going to need him back for 1:15.
For 1:15.
All right. Without further delay, we're going to go ahead and call the next witness. State.
This Hilton calls Kenneth Copeland to the stand.
All right, summon Mr. Copeland, please.
Ooh, honey.
Governor, here's that. Mr. Copeland is.
All right, just here he comes.
No, he coming. Leave the boy alone.
Go ahead and approach witness stand. Before you sit down, if you
Learn how to talk to
face,
people.
Deputy Hand be sworn as a witness.
Of course, he don't want to testify. This look, he aggravating people.
Kenneth Copeland.
Mr. Copeland, do me a favor. Pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
Spell it, please.
KENNETHCOPELAND.
Thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay.
I know that
Let me
right.
ask you some questions.
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you said you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters, your jury deliberation, please? From
All right, for sure.
Y'all stop picking at that boy. That boy, leave him alone. Go on. You already know how old he is. He don't want to be there. Y'all know that. Start agitating him. That's y'all state witness.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
Woo! They gonna lock him up, y'all. Ain't nobody got time to be getting, dealing with attitude.
All right. State, do you have any other witnesses you plan on calling this afternoon? Okay. What I'm going to do is I'll call our jury and tell them that you're going to be in recess for the weekend, and we'll come back on Monday. At this point in time, there's really, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Copeland is he's going to testify.
So everything you say, I'll adopt, because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. The last thing the court knew, and he has counsel.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and they've heard Mr. Copeland's name however many times a court reporter says.
Casey, that's what we've heard.
No,
So.
the jurors have heard Kenneth Copeland.
And as well, okay.
I opened on him that he's the killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew,
She just won't sit
reason to
still.
believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial.
Okay.
Okay.
All right, sir. Thank you. All right. Yes, sir. It would apply to everyone. Yes, Ms. Love.
Your Honor, I'd just like to put some things on the record
Sure.
regarding Mr. Copeland. As we stated earlier, Mr. Copeland has,
Your Honor, I'm just telling the court, I am not accepting the proffer.
Your Honor, if I may.
Okay, but counsel
May
gets
I?
the proper, Mr. Steele. I can accept that. So, could you sit down, sir? Okay, thank you, sir. All right, Ms. Love, you can complete your proper at this time.
Your Honor, yes. Just to relate to the court the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak, that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and
Yeah,
counsel
I'm
for
gonna stop it
defendants.
right here.
And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants after Mr. Melnick attempted to assert for Mr. Copeland. May I finish?
Let her finish, Mr. Melnick. Please sit down. I'll let you start. Okay? All right, thank you, sir.
While Mr. Copeland is
She
on the
got a
stand
little
stating that he
attitude.
wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it. Then, upon information and belief, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in. Then, as
Does he at any point in
Mr.
time tell you?
Copeland,
Does he at any point in time tell you I'm not going to testify? I'm
No,
going
no.
to invoke the Fifth Amendment.
no, as what happens,
I don't
as
believe
Mr.
it.
Copeland requests
I don't
to speak
believe
with the
it.
state,
Miss Love.
Mr. Melnick keeps going in, regardless of Mr. Copeland's request to speak with the state, and then
He
we
plead the
learn
fifth.
that Mr. Melnick tells Mr. Copeland they are going to hammer you. So Ms. Hilton comes back in and asks me, had I spoken with Mr. Melnick? Had I told him that we are going to hammer Mr. Copeland? The state had not made any.
Why didn't
such
she have to
communication
snap
with
after
anybody.
everything she
So
said?
what we are seeing, we believe, is tampering with witnesses. This particular witness on the part of
Miss
people who are
Miss
not
Love
safe.
love the fuss.
So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks, and after Mr. Copeland has communicated to this court, he will testify. So
I don't believe
the
it.
goings on as Mr. Copeland is not on the stand, it has been publicized, it has been hyped up that Mr. Copeland is the next witness. Mr. Copeland is the witness. And then Mr. Copeland, he's been nothing but
He don't want to.
cordial.
He don't
He's been
want to
nothing but
testify.
communicative with Ms. Hilton during the time that she has been interviewing him and speaking with him. And the reason Ms. Hilton was not in here just now when the jury came out is that Mr. Copeland asked to speak with Ms. Hilton. But Mr. Melnick kept going back in there and going back in there and going back in there. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us to call into question whose interests he's representing. And so we would ask that, you know, what I haven't even thought of in my mind an appropriate remedy at this point, because it is wrong for parties to inject themselves on behalf of purportedly one person and
Oh, she'll be up here all day, y'all.
And investigative law, and I may be wrong. Heard Mr. Copeland prior to coming into the courtroom, almost immediately prior, state, and I'm reading from Mr. Kokomo, if I have to go to jail, then lock me up, and then the Honorable David Box told me, as I was walking in, that he heard, he's right behind me, so he should speak for himself, but he heard Kenneth Copeland tell the prosecution, if I said it wrong, it's corrected, that he's invoking the fifth. That's why I raised it. I'm not saying anybody...
He said that when he came in the courtroom.
Already knows or has a reason to believe that a witness may invoke the Fifth Amendment in front of a jury. We avoid that at all costs.
But the challenge we're having, Mr. Steele, is I do believe that there's probably been some behavior that probably wouldn't pass the good faith test of there's a lot of influences inside and outside. So I'm going to basically base it on the proffers of counsel and just remind you all of your professional responsibility requirements, okay? So I'm going to...
I'm just telling the court that in order for you to deny my motion for witness is bad.
And I'm going to deny your motion, and I've made my ruling. So I'm done at this point in time, okay? In terms of this motion for mistrial.
Well, I'd like to call the witnesses, but I understand what you said.
I'm not going to call any witness. I don't need any witnesses. Your proffers are fine, okay? Yes.
We are in a side room off the hallway on the first floor. That's where defense counsel is kind of their conference room. During lunch, I'm working on unrelated matters, and I'm going to get a ginger ale to calm my upset stomach, and I'm on the phone, but I'm hearing a gentleman speak very loudly on the phone with agents from the state. I believe agents from the state were present within earshot. And that gentleman on the phone, who was Kenneth Copeland, was making...
How do you know it was on the phone? If Kenneth Copeland's on the phone, is he talking on the phone, or?
He's standing in the hallway 10 feet from me, practically screaming in the phone.
Oh, so Mr. Copeland's on the phone?
Yes.
Okay, and you're overhearing this particular purported conversation.
I'm not testifying, I'm not giving a direct quote, because I was on the phone handling my own business, and I was having no interactions with...
Okay, but here's the thing. I think it's consistent with... I'm not testifying, okay? He can make a decision not to testify, okay? But if he does so, and because he's already been told, look, you can invoke your Fifth Amendment privilege, and you've been given immunity, and if you don't, I told him what the consequences are this morning. That's consistent with what I've heard thus far, and I don't think that is...
I believe that the state was on notice.
Y'all making somebody.
Okay, all right. But all of you have kind of, like I said, either unwittingly or I just remind you, from outside agitation or otherwise, you all need to stay away from any of this. You do. Both sides need to do this.
Y'all do.
Do not let outside influences influence your actions and get you in trouble. You all should rise to a higher standard in terms of don't let any of this stuff. I mean, these.
He said he didn't want to testify, but y'all threatened to lock him up.
I didn't say you did anything wrong. Okay, but I didn't say you did anything wrong, but
I understand, Your Honor, but I just want to be clear. The only thing that I've heard today is that the state met with Kenneth Copeland without his attorney.
Are we going back to that again? I thought we...
I don't know of any defense counsel that's had any conversations with Kenneth Copeland at all. And I just want to make that clear. today, I don't know of anyone that's had a conversation.
Okay, but he's their witness at this point in time. If he wants to talk to you or he doesn't want to talk to you, he's got a lawyer, and that lawyer can make that decision, and so can Mr. Copeland. So
Situation because
I understand that, but you can't let other people, and I would advise you not to let third parties influence what you may think a witness is going to do.
that's not happening.
Okay, and that's all I was trying to tell you. Okay.
Miss Love, very fussy.
Yes, sir. What does he like to tell me, Mr. Melnick?
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case. Speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal.
I don't want you to do that, sir.
I can assure you that the decision to invoke the Fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for any assertion, I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right.
Miss Love got the fuss. Look at
For
her.
an assertion to be made
Better
that
put that
I or
man
Mr.
power
Copeland
on.
are somehow being
Nobody wanna
influenced
argue
by
with you.
somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what
Throw
the
it.
court,
Get
the
her.
court is ruling upon. Remember, the court can only rule upon what I see.
I
Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He
Peace.
said, "I'm going to invoke my Fifth Amendment privilege." The state came to me and said, "Okay, listen, we would like you to sign an immunity order under 24-5-507. They make that decision. So there are. I mean, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was going to invoke his Fifth Amendment privilege. So
Absolutely do.
So, but in order for them to still get this testimony, which they believe that they need, they offered him immunity. So that's what we explained to your client this morning. So whether or not he wishes to go ahead and,
I believe they were aggravating him.
that's his choice. But the statute's pretty clear.
I understand.
And I know you, and I know you have known you, sir, for at least two decades.
Get Miss Love,
And I know
punish
that
her.
You have told him, hey, look, if you invoke, this is probably what's going to happen. And I suspect that if you probably have a conversation with him now, you're probably going to tell him, well, that was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with him, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go ahead and I'll call him out before the jury comes in on Monday morning, and we'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it once already, I'm going to ask him before the jury gets out here on Monday, is it your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland
Be
wants to do.
professional, Miss Love.
That's probably not true.
It is grossly unfair.
Be professional. Stop acting like that.
I've known
Acting out
Miss
ghetto.
Copeland and Miss Love in particular for a long period of time, and I don't think that they would do that to you. And
Judge, at no point did they ever reach out to me about Mr. Copeland.
He telling you, Judge.
About Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness because
When did you talk to Mr. Copeland?
last Friday, because my understanding prior to then is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime that Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays when we picked him up for the first time, on Tuesday when he did not take the stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home, and then yesterday he came back down here with us. Again, we showed him some of the evidence that we were going to show him, and that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client, and then my client is going to plead the fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right, so we have a witness that may not have been totally candid, or may not have thought that he potentially needed you, and as things developed, Mr. Melnick, he decided, well, yeah, he does need you.
Yeah, that would have sounded like.
Whether or not.
And Your Honor, it's my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my client.
No, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't,
Sit down, Miss Love. He already straightened it out.
Don't put yourself in a position where you come cross purposes with the rules, okay? Of course. And that sometimes has to be explained to witnesses and clients, okay? All right. So that's where we are at this point in time. Is that Monday morning I will bring Mr. Copeland back out. It is I don't relish the fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So we'll take him up because that's our first session of court.
She ready to open up that mouth.
Your Honor, I would like to ask that the court convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial. Because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us,
of the trial,
as Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled.
She want to see these black men locked up.
So there is nothing that we could do to Mr. Copeland regarding any
locked up to the end of the trial
on the stand pursuant to the court's order under the statute that the court has cited, 245507, and that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
Okay, so Mr. Melnick, if you do in fact talk with Mr. Copeland, like I said, I'll bring him back on Monday. We'll see where we are at that point in time.
Okay.
And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is.
Yeah,
in case,
just-
okay.
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that off the record.
Okay, I'm going to recess in just a little bit, and but can you be back for Monday morning?
That's just it. I can't. Is this something I can take up off the record?
Well, I kind of have to call him on Monday. I do. I mean, there's no choice. I have no choice because that is the next session of court.
Judge, I have non-refundable tickets out of town on Monday. I can't be here. I cannot be here. And there's nothing I've had this on file with Fulton County since December 15th of last year. And again, had the state contacted me before today, I would have made them aware of this.
Well, there's one of those times as a lawyer that you're going to probably have to kind of figure out a solution, sir. I mean, I don't want to put you in this particular position.
I can't be here, Judge. I absolutely cannot be here.
So you're gonna have to.
Choice. You can be here if you want, but you'll have to figure out some other things to do with your tickets. I mean, here's the thing: if you're asserting, if the state was relying upon the fact that you were not his counsel, and now you are, you have put us in a situation where now you put yourself between a rock and a hard place. I mean, so he's coming back on Monday.
I'll have somebody else make my
Then that can be done, and sir, I would advise you to do that. But remember, Mr. Copeland, has to have some concurrence. So maybe before he leaves and goes actually to the Fulton County Jail, you may need to have a conversation with him about that, so we're clear, and I'm clear as to
We don't want to see nobody in
coming back
jail.
on Monday or somebody else is,
I'll have somebody go.
and I need to know who that lawyer is. Do you want to have a conversation with him before?
Talk to him right now.
All right, okay. I'm going to allow you to do that, and then I'll remain and be available for
Good job, Judge.
So let me go ahead and.
Good job, Miss Love and Miss. Okay.
Sergeant Ham, can you and your colleagues or Lieutenant Walker arrange for Mr. Melnick to talk with Mr. Copeland, please? All right. And I'm going to go ahead and at this point in time summon our jurors, please. All right.
That was very interesting. And I knew it was going to end up like this because he was in defiance that he didn't want to talk to them, period. But he's not a little bitty boy no more. He's a young man, so he has to get up there. And he was subpoenaed to court, and he had to follow the rules and the laws. So if he want to go back to jail, he just go to jail. But it is what it is. And I would I won't keep nagging at him either. Like, how old, he said the boy was wrong. The witness was wrong. He was wrong. That's all I got to say. The witness was being disrespectful. He was being disrespectful to the state because he didn't want to talk. And that's wrong. So y'all tell me what y'all think about that. Like, share, and subscribe. And I'll see y'all Monday. Have a good weekend.